Hajka CM. Hajka CM. Well, thanks for all coming out today. Deja vu for us, and makes me think of what is the definition of insanity? Doing the same thing over and over again, expecting a different result, but getting the same result, and I think that's where we're at today, and this is what Trudeau's putting through the Canadian people again. We're doing because it's based on fact. It's fact. It's not good for Tsleil-Waututh, Vancouver, British Columbia, Canada economy. It's a risk that we're willing to take. We have proven it over and over again by revamping our 1,200-page assessment, revamping our economic study, which I mind you they didn't do. Doing our air, we just finished an air quality study, but we also did a spill analysis. We did a cleanup analysis. We're in the process of doing a health study, but we protect what we have too. Our salmon count went down to 6,000, and we brought it up to millions in a year. We reintroduced elk into our traditional territory that brought back grizzly bears and wolves. First time in 35 years, we did a clam harvest in this dirty, polluted inlet that happens to be our mother. When we say Tsleil-Waututh, that means people, the water right here. We have a reciprocal relationship of spirit to the lands and waters, and that's why my relations right here, my family, are standing up and we're saying no, because we have proven over and over and over again that this is not a good project. The shareholders at the Kinder Morgan AGM, we spoke there. After we spoke there, we explained to them that it's not a deal that's not good for their investment. Richard Kinder got really mad, started yelling. I pointed out he wouldn't be mad if I was wrong. But the shareholders listened. And their stock fell by 60%. Their dividends were cut by 75%, 60 days after we spoke there. And this option that they have, the taxpayers don't have. You're stuck, invested into a bad deal, a brutal deal. And you don't have the choice to pull your money out. And Trudeau's making a political choice to support his rich friends. That's what it was about. If you recall, Kinder Morgan, when they had their last AGM around this, they said nobody for a whole year, remember that? A whole year wouldn't buy the pipeline. And then Canada did. They said, we made Canada buy it. We made Trudeau buy it. That's what they said in their own AGM. So they knew it was a bad deal. And we have proven it over and over and over again. What is saying their lies. And we're proving it still, and we'll prove it again in court. We're in this room 2 years ago, and we said the same thing. The Canadian Constitution protects our Indigenous rights, Section 35. And we've won over 250 legal cases in the last 3.5 years. You know, the tides have changed, and because he's incapable of making sound decisions, I say this to protect the Canadian people and their future generations, even his own. My people right here are. I raise my hand to the nations, the 6 nations that filed yesterday. I raise my hands to them. Would have been in standing up to stick up for that reciprocal relationship of spirit that we have with our lands and waters. The most beautiful place to live in the world is Vancouver. Consistently voted at that. We're protecting it. We're protecting it. We're protecting Canada, because this government can't. And the Conservatives are worse. So we're gonna stand up, and we're gonna continue to fight. So I'm very proud of my nation and my people and the nations that are standing up here with us. I'm gonna call up my sister and my chief, Tsleil-Waututh Nation, to come up and to share some words, and also acknowledge the chief and council that stand behind her, HKCM.
ACM Siaya, Ait, Tanashkwalawan, E Quick Quitsnala. Greetings to our honored guests and my dear ones. I have good feelings in my heart to see all of you today. My name is Chief Leah George Wilson. I'm Sitsia Ama of the Tsleil-Waututh Nation, and thanking all of you for being here. And it does feel like deja vu. We have been here before. 2.5 years ago, we were announcing our last court challenge, which, as you will recall, we won. The Federal Court of Appeal ordered Canada to redo its consultation. Canada had the opportunity to get it right. and they did not. We have not seen any significant difference in the consultation process. In some ways, it was worse. Tsleil-Waututh is therefore seeking leave to appeal at the federal court level. We are stating that the federal government's approval of the pipeline is unlawful and must be quashed for the following reasons. Consultation was not meaningful in the following ways. Canada was not responsive to TWN's concerns, which include oil spill risks and impacts to the killer whales and our significant relationship with them, climate change impacts, project economics. The project infringes our Aboriginal rights and title, including our ability to practice our culture and ensure future generations can use and enjoy our territory. Canada would not extend its timelines for meaningful consultation. Canada withheld information regarding their scientific assessments of diluted bitumen impacts and only provided this information to Tsleil-Waututh after the formal close of consultation. Canada was biased. The federal government is in a conflict of interests as the owner, regulator, and enforcer, as well as the fiduciary for First Nations, as well as the fiduciary for taxpayers of Canada. The federal government's decision to buy the pipeline and become the owner makes it impossible for them to make an unbiased, open-minded decision. TWN is also seeking leave to appeal due to legal and regulatory errors at the National Energy Board. The NEB only assessed project impacts within 12 nautical mile limit and not the 200-mile exclusive economic zone, which contains the southern resident killer whales' critical habitat. The NEB also relied upon outdated economic evidence from 2015 or earlier, which is no longer relevant and therefore cannot be used to justify the project impacts. We believe that the consultation once again missed the mark set by the Supreme Court of Canada. Tsleil-Waututh participated in consultation in good faith again, but it was clear that Canada had already made up their mind as the owners of the project. We have no choice but to appeal again, and we expect the same result, that the approval will be overturned. We'd like to thank the First Nations and the NGOs that have joined us in this struggle. We have our good friends, Cookby Ron Igneous from Chequamlip, as well as legal representation for Shwahamo First Nation. And we thank all of you Canadians that support us in this struggle. Haitsepka, thanking all of you.
Waid Kuwaitip, Gedaks as ma Klultun Kunanas Kimstetten and at the Kalmochut Mix is Nuchen Tasco as Ulks and Chitus as Ichumen Stam Kochut Mix. First, before I speak, I'd like to raise my hands up to the people of this land who have allowed us into their house to conduct our business here today. I'm Chief Ron Ignace of the Tsleil-Waututh Nation. My community is Skitchiston, but I'm here representing the Skamloops, the Tsleil-Waututh Nation, SSN. As you know, SSN is known for standing up to the KGHM Ajax open pit mine, in which we fought with using Tsleil-Waututh law to not allow it to go forward. And today, I want to tell you about where our stand is. They tell you that the pipeline is simply being twinned in the same area that we're dealing with in Kamloops. But that's not true in our case. Canada's decision is to dig up our sacred site known as Peepsit, the area in which the big open pit mine was proposed that we had turned down. In previously undisturbed, turning up our burial grounds rather than consult about reasonable rewrote, we continue to protect Beepsel for the benefit of all Canadians. Canada, as owner of the pipeline, is in unique position. Canada has an obligation and a responsibility to balance and the potential adverse effects of the proposed project on SSN's Aboriginal interests with broader social interests, even where balancing SSN interests may mean a greater cost to the pipeline, and it may not. We participated in the consultation process with an open heart and a willing ear, and we were met with the same response as the last time, a closed mind and a heavy hand. Trans Mountain and Canada have never made efforts to consider reasonable alternatives to the proposed rerouting of the pipe project. They have delayed and neglected to address the issues, and now it is front and center. This reminds me, the way the government is dealing with us today reminds me of how they dealt with our chiefs that gave rise to them saying, we are of the understanding that there's one law for the rich, there's another law for the poor, and yet another for the Indian. And that is what we feel today. Canada says that the adverse impact to our sacred site is a temporary limitation on access, acknowledging that Beepsel would not be returned to pristine, but no mention is made of our laws and governance as caretakers of the land. We have a law in Shuswap country. The name of that law is Yuchuminman. It bids us to be caretakers of the land. No mention is made of the physical destruction of Beepsel and the harm that would cause to our people and future generations. No mention is made of our choice not to destroy this sacred site. Would you dig up your graveyards, move your families, disturb your ancestors, and would you stand by and let that happen? We simply cannot and should know better. And it was mentioned here about the salmon. Let us not forget that the Shuswap Nation is one of the bigger producers, one of the few producers of many salmon. We have the Adams River Run, we have the North Thompson, we have the Horsefly, the Likely, are all great. So anything that disturbs the marine will also cause us harm in our ability to move forward in our traditional lifestyle. And so, in so doing, in Canada moving forward the way they are, we declare that the Crown breached its constitutional and common law consultation duties, failing to uphold the honor of the Crown, and by denying SSN substantive consultation. And so, in essence, the government, GIC, failed us in its constitutional and/or legal common law duties to ensure proper procedures. So, thank you for hearing me out.
Good morning, everyone. Like my colleagues before me, I really like to acknowledge this beautiful territory of the Squamish, Tsleil-Waututh, and Musqueam peoples. Thank you very much for letting us be with you here today. I'm here as a representative of Shwahamo First Nation. They're participating in one of the few First Nations that's been added to the judicial review. So instead of shrinking the number of First Nations that were participating in the judicial review, Canada's actually expanded it. And the main reason that that is the case is because Canada has broken the law. Canada's going, there's a very particular pressing issue for Shwahamo, similar to our colleagues from SSN, in that they are fighting and are participating in this judicial review to protect their sacred site. When the first Trans Mountain was built, Line 1, it destroyed parts of their historical village, and the plan is to build the pipeline, as we know, right beside Line 2 is intended to be right beside the existing pipeline, and that will destroy a further 20 pit houses and largely destroy their entire historical village. Included in that historical village are burial sites, all sorts of archaeological rich information, and I think when I say that it would be contrary, it would break the law, is it will break Stolo law, it will break Canadian law, and it will break international law if Trans Mountain is allowed to advance their project through this historical site. So that's the main reason that Shawhamel has had a change of heart in terms of their approach to this project. There's already been media coverage on it before, but Shawhamel is unique in that it originally was a supporter of the project and now is in opposition and joining the judicial review. And it's for that one singular reason, is that Canada continues to advance this project contrary to the law. There's like many other First Nations, Shawhamel is heavily dependent on the Fraser River. Their First Nation is probably about like 500 meters to less than a kilometer away from the Fraser River. Then there's the Trans-Canada, and then there's the Trans Mountain. So if there was ever any spill on their territory, it would be catastrophic to them. It just wouldn't be an environmental cleanup issue. In some ways, Shawhamel as a nation would cease to exist, because their territory is, particularly their core Aboriginal title lands, is so close between a mountain and the river that if there was any spill within their territory, it would be catastrophic to them. So that's another one of the main reasons that they are joining this judicial review. I guess the third, and which has always been another very important issue, is that underneath the Shawhamel Reserve is an aquifer. In fact, actually, it's not dissimilar to Coldwater Indian Band, who's also part of the JR. They have a very clean water source, which all of their water constantly flows underneath their reserve, which the pipeline is above right now. So if there was a spill, it would destroy their sole source of water. So it's for those three reasons that Shawhamel has elected to join the judicial review. And I think it goes without saying that this is a very sacred issue to Shawhamel, and that if it advances, it will break their sacred law. Those are my comments. Thank you.
We understand, and actually have spoken with some of the First Nations that are in support of the pipeline. In the beginning, we did do outreach to all the communities along the pipeline, but we also would like to remind people that First Nations, we all have an interest in our inherent and constitutionally guaranteed rights being protected. So we have the right to say no. And that potentially the pipeline is owned by other First Nations doesn't extinguish our right to say no. We still are owed the same duty of consultation and accommodation regardless of who owns the pipeline.
Yeah, I think you're probably mostly referencing the 43 First Nations that have signed mutual benefit agreements, and then those that are potentially looking for an equity purchase. I think what's important for Canadians to understand is that who the owner is will not cure that there's been a consultation failure. I mean, it didn't cure the project when Kinder Morgan, a Texas-owned company, was the owner. It didn't change it when Canada bought the project and it became a Crown corporation. And it won't matter whether or not First Nations purchase are shareholders also. Like, it's just very simple that who's the owner won't cure the fact that Canada has failed to consult appropriately. And I think, at least for Shawhamel's purpose, they respect the free, prior, informed consent of other First Nations to do their assessment and then make their decisions yes or no. We're not trying to disrespect their decision. We're just asking other First Nations to respect Shawhamel's.
In our view, the federal government made many of the same mistakes as last time. They had a limited mandate to address our concerns, a compressed timeline, and there were many unresolved issues. Our concerns remain unaddressed. These include oil spill risk and effects, The likelihood of a spill has been underestimated. An oil spill is inevitable, and we cannot effectively clean up all of that toxic sludge, and there hasn't been a proper assessment of the project. They haven't addressed our concerns around the impacts to the killer whales, southern resident killer whales in this inlet that have been in to visit over these last 2 months and all of this discussion. Of course, there are climate change impacts. It continues to contribute, the pipeline continues to contribute to climate change and is incompatible with the direction that Canada is supposed to be going in. We talked earlier about the uneconomics of the project, as well as how the project infringes on our Aboriginal rights and title. And all of this shows that the consultation wasn't meaningful.
There was a Supreme Court ruling that was we enjoined with Tsleil-Waututh. In there, we laid out 5 key positions, and the judge, in overturning the decision on our side, pointed out that those 5 key issues were live issues that had not been dealt with. It was dealt with through notations, and again, we had the impression that the consultation was not serious, was not deep, and was done just through notations once again, which is not the proper procedure. It was harried, we were rushed, very little time frame for us to, and we weren't provided with the proper resources to be able to answer some fundamental complex questions, which a consultation of this nature has to give us a much more robust and in-depth opportunity to respond. We did not feel we got that, nor did we know we didn't get it. So therefore, this process was equally, if not as worse flawed than the first time around. So this decision ought to be quashed. Thank you. And I would like to say to the ordinary people out across Canada, our fight is not with you. Our fight is with your government, with the leaders that are making these kind of decisions. However, you have a duty and a responsibility to see that your governments do the right thing by us, and that's both provincial and federal governments. Thank you.
Yeah, thank you for the question. I think, for Squamish, the real clear difference between, I guess, the last time and the last consultation and this one is that actually Squamish wasn't actually consulted the first time, so I guess the contrast is very stark in that circumstance. Any First Nation that actually signed an MBA and said they were in support were actually skipped over by the federal Crown in consulting, so they didn't even have the note takers sent out to them. So this time, I think the contrast was more stark because the court was asking for us to have an iterative process, a two-way dialogue, and expected the consultation to be deeper, especially where it was clear that the lands in question had prima facie Aboriginal title, where the consultation would be at the highest level, if not consent. So Squamish went in good faith into the process, assuming that they would have this deep consultation. But in fact, what happened was a very superficial and often contrived process, where the Crown seemed to already have a list of accommodations that it was willing to accept, had created this list and just sort of waited to sort of roll them out. And in the end, the list of things that I think the First Nations asked for, especially Squamish, was more like about 20 different tangible concrete measures, and Canada's 8 accommodation measures were things that they had not actually requested. So there was this the two parties just spoke right past each other, and it was never, and at least I think in our experience, it didn't seem like the process was ever in good faith. It seemed as though they had decided ahead of time what the accommodation measures would be before ever meeting First Nations. It was intended to create a false narrative of consultation so that Canadians feel, okay, well, at least they went out there and tried harder with First Nations. It didn't work because some of them you can never convince. But the reality is, I think many First Nations, probably most First Nations, entered the process in good faith, with an open mind and an open heart to try and actually see whether or not they could advance accommodation, except for what they found was the candidate had already put its mind to it. And I think that actually touches on something that Tsleil-Waututh had mentioned before, which is that it seems that Canada's bias to advancing the project weighed so heavily on timelines, on the type of accommodations they were willing to do, especially accommodations that might make the project uneconomic. Reroutes are very expensive. So, I mean, I think all of those themes, you get the sense that that bias plays itself out into the accommodation that Canada was willing to do. And of course, then you get this contrast where we're asking for one thing and they're offering another, and they're not truly listening to each other. Well, I think the luxury that we have in some respects in this case is that the court required Canada to do a deep consultation. So what you'll find actually is, in this case, the facts are explored far deeper. Instead of just having First Nations asking for things and then Canada just taking notes, you'll see it'll be a much more forensic look into the way that consultation actually occurs. I think what's going to be even more live this time will be whether or not Canada actually acted in good faith. And of course, I think the change in ownership issue will also be, I think, a very live issue of whether or not Canada was in conflict of interest or had a reasonable apprehension of bias. I think those are going to be very live legal issues. I mean, clearly the environmental issues related to protection of Orca residents is also very live, and the fact that Canada is failing Canadians and failing Indigenous people on protection of species at risk is another very live topic, which won't just be sort of touched on superficially in that they ignored it. And this time they sort of paid attention to it and then weighed the national interest or economic interest before environmental interests. So I think those are going to be some of the different issues. I mean, the reality is that for some parties who have submitted 8,000 pages of documents, there is a lot of argument to go through and do a comparative analysis. I think what you'll find is there are some of the same failings have repeated themselves, and then there's a whole bunch of there's more failures than there was before.
I think now what we'll do is we'll take individual questions that are available to answer any further questions. But thank you all for coming. You know, more optimistic than ever with what we have done. You know, all the studies, analysis, and assessments that we have done. Starting to work on our health study and just finishing the air quality study. On top of everything else that we have done, we're very comfortable of going through a fair process. This was not a fair process. And as you seen last time around, victory was huge for First Nations, and we expect the same result. And so thank all my family, the chief and councils and the representatives and the speakers for coming up and standing so powerful and so beautifully. And we thank you all for coming, and Hajj Kasiyam.